family members lining up behind the prosecution bench, hugging one another over this verdict. This was a sweep for the state of Florida in this case. Brian Wagner, criminal defense attorney, is joining us here in studio in the Law and Crime Network. We were talking a few minutes ago about this not being a surprise. Now it turns to the penalty phase. I was just taking a look at the list of witnesses that the defense is planning to call to try to mitigate this and make it a life in prison, not a death penalty. It's a lot of relatives of the defendant from up in Pennsylvania. Oftentimes, not all of the proposed witnesses are put on the stand, but what does that tell us about where things might go on Monday once they start the penalty phase of this case?
So during the penalty phase, the defense is going to talk about mitigation, factors that the jury can consider to not put Mr. Matos to death. And the way mitigation works in Florida is if even a single juror decides not to commit a death penalty, then the judge cannot do it. They could unanimously recommend the death penalty, but ultimately the decision is by the judge.
How often would we see it, though, that a judge just ignores a jury's recommendation of a death penalty sentence?
So that I can't tell you for sure. What I will tell you is judges take sentencing very seriously, and they, in their estimation, try to mete out whatever the appropriate sentence is. Here, the mitigation factors that you'd want to consider are in the totality of circumstances. One mitigation factor can outweigh every single factor otherwise that the people would put forward. It's really a balancing test that's subjective. Each person holds by themselves.
The aggregating factors are an enumerated list, but in theory, anything can be a mitigator. It can be anything that ever happened to the defendant. It can be anything about his family, his upbringing, his history, that his mother thinks he was a nice kid when he was 2 years old. It, in essence, can be anything. So at this stage, the defense's theory or strategy might be throw anything we've got on the witness stand to try to save his life.
Absolutely, and that's what I expect to see, is anything they can muster up to say, to somehow explain why the defendant did these violent acts that he's now been convicted of. Anything at all, not to justify it, but to somehow put it in its full context. And that's what I expect the defense to do.
This jury took 2.5 hours to reach the verdict. This was quick. This was a sweep. The jury had to start with the top charge on each of the counts. It looks like they just went back there, maybe batted the issues back and forth for a little while after introducing themselves to one another, finally being able to talk, and just said, hey, look, 4 people are dead. He tried to get out of the house when the police started crawling around days later. He lied about his whereabouts when the police finally got him. He bought a shovel. He tried to bury the bodies right near the house and eventually transported them to a location about a mile away and dug there, where he could finally hit enough soft ground to try it. You know, that looks like the act of someone who is guilty, not someone who was in self-defense and then reports it right away.
So there's basically 2 defenses. When you boil them down to everything, there's 2 defenses. Mistaken ID. In other words, this happened, but it wasn't me. Or, yes, I did it, but I was justified. Self-defense. The hardest thing for a jury to do is sit in a courtroom and know that they're in the presence of really evil acts. So most often, mistaken ID is the safest defense. In this case, the defense decided there's no way we could really distance ourselves and say he didn't do it because of the overwhelming evidence that the prosecution put forward. His actions afterwards of trying to hide the body, hiding the guns, selling the dogs, being at the location. And so they're left with what's usually the harder defense, self-defense, justification. And really, the defendant's own actions afterwards made that impossible as well. And so that's why the 2.5-hour verdict is really, it's a measure of the jury now knows they're in the presence of what are evil acts. Now, was he allowed to do it? Was he justified? And for them, it was pretty easy to say no.
Was it a good idea for this defendant to testify?
So, who knows? I will tell you generally, unless you have a very compelling reason to testify, you have the right to remain silent. It is probably the most important right a criminal defendant has because the defense doesn't have a burden. And so by taking on that extra burden, by testifying, The jury now gets to evaluate your credibility, a defendant's credibility, just like they would any other witness. And so any inconsistencies, this doesn't make sense, it's not common sense, it's not logical, the jury gets to consider that. And Mr. Matos' testimony had quite a few of those.
The state got up there and argued that the defendant, by his own words, more or less confessed to first-degree murder, at least with victim Nick Leonard, on the stand. And one has to sit and wonder what was going through his mind. Did he not know that he was going there? Was this something he talked about very thoroughly with his attorneys? Was this something that was an overnight decision where he decided to get up there and thought it would come across well? So what was going through his mind?
So the client, the defendant, has the constitutional right. He and only he gets to decide whether or not he's going to testify. So for all we know, the attorneys were telling him, don't testify, it's a terrible idea. We'll prep you, we'll go over this over and over. But in the end, Mr. Matos makes that decision. And in terms of why he admitted to Mr. Leonard's death in the manner he did, I don't know. I agree with you. That really was essentially an admission of first-degree murder because it was after everything had already occurred and he was already disabled.
Yeah, so the story went that he was, meaning Leonard, was stabbed, and then Matos said he went back and then pummeled him to death. You know, there were, more than 20 wounds. So that time frame is enough to form premeditated intent. And we wind up with a verdict that we wind up with. You know, part of me wonders if what was going through Matos' head, and I'm not sure if I'll ever know, part of me wonders if, look, I'll buy that this house was probably a pressure cooker. You know, he comes down from Pennsylvania. He had lived in Pennsylvania his entire life. He's down in Florida. You know, he's living under the same roof with the mother of his child. She apparently takes an interest in other people, and he's there along for the ride. And did he feel like a third wheel? Well, it's at least arguable. I would say it's probable. We know that there was a lot of tension in the house based on the testimony and the depositions. We know there were arguments between Matos and the family. We know there were arguments between Matos and Megan Brown. Greg Brown had to get in the middle of them from time to time. So this seems like it was a situation that was an increasing pressure cooker. And less than 2 months after they all moved down there together, 4 people wind up dead. Part of me wonders if Matos got up on the stand to try to say, this was just the way that I reacted to this pressure cooker situation. That he wanted people to know just how bad it was in his mind for him to be in this situation. But people aren't going to buy it. You know, look, if it's that hard for you, leave, walk away, go get counseling, do something adult. So, but it makes me wonder if that's what was going through his head. I mean, it's a guess, but it's at least probable. It's
absolutely possible. It's absolutely probable. And with Mr. Matos, the best thing a prosecutor can ever say on summation is, ladies and gentlemen, the defendant agrees with our case. Here's what the defendant told you, A, B, C, D, and it's corroborated by the people's own evidence. Here's what the defendant told you that doesn't make sense. And that's a powerful closing. That's a powerful summation argument. Because now what you're saying is, even by the defendant's own admission, he's admitting to all these factors that make up our case. And that's what the prosecutor really did in this case, using that Leonard admission that we had just talked about.
You know, some people in the chat room are reacting to an issue that popped up earlier in this case, and that was a member of the jury pool saying that he's too good looking, it'll distract me to sit on the jury. And somebody's jumping in saying, oh, he's going to be the best looking inmate in prison. I see these comments. You know, he couldn't charm his way out of this one, though. No. The jury didn't pay attention to that. Kudos to the judge and the attorneys. They cleaned up that problem in the jury selection process. Good job. You know, did he think he was going to be able to charm his way out of first-degree murder charges?
I don't know. I mean, you have 4 people that were brutally murdered. And you saw in the very beginning of the case where the defense was making motions in limine to remove certain photos that they said were too gory and too graphic. When the jury's faced with that sort of evidence, we tell them to put sympathy and bias aside. Whether that's sympathy because the defendant is so good looking, or if that's sympathy because he reminds you of a family member or a neighbor or someone else, you put that aside, and once you're kind of confronted with those really graphic images, any ability to turn a blind eye because he's very good looking, you kind of forget that. Most juries would.
Yeah, and look, the piece that we put up on Law News with the conversation back and forth between the judge and the attorneys about this issue did take some traction. Some people were commenting about it. But look, that's what the voir dire process is for.
Absolutely.
We try to ferret all of that out and deal with it, getting rid of any bias, whether it's looks, whether it's something else, whether it's pretrial publicity, whatever it is. Maybe a member of the jury had a family member who was a victim of a similar crime. That can cause possible bias. Maybe a member of the jury is distantly related to or knows one of the attorneys. Any of this, we deal with it. We get it out of the way so that we can feel confident in the verdict once it comes down.
Absolutely. And that's, like you said, that is what jury selection is about. What you often tell jurors is, we want to find out if you're a good fit for this jury. There's many other juries in this building, and another case might be a better fit, but we want to know if you're just a good fit for this jury. And if you have a very attractive defendant or a very attractive witness, maybe a different case is better for you.
So let it be known from this point henceforth that even if some members of the jury pool may or may not find the defendant attractive, that doesn't mean he's off the hook, or she. So we can settle that debate for now. I wonder what's going through his mind. Is he regretting testifying?
Who knows, really? I mean, that a defendant, the only person in a room that knows for sure whether or not something occurred is the person sitting at the defense table. And so he's been having a long time to think about this incident. Whether he was prepared for this day or not prepared for this day, you'll never know. But I think it does speak to the penalty phase of what he actually was thinking if he does testify during the penalty phase. I think that will show you what his really psyche is, and that goes towards mitigating factors or aggravating factors in the death penalty phase.
We are continuing to monitor another trial here on Law News. That's the Shelby Isaac case out of Tennessee. Interesting case. If we can try to go back there, we're going to see if we can. But in the meantime, want to go back and continue to listen to some of that dramatic testimony from the defendant himself. We're going to review a little bit more of this because ultimately the testimony didn't work for this defendant. This was a sweep for the state, 4 guilty verdicts, first-degree murder. Now we move to either a death sentence or life in prison for Adam